Let's look at terms of a contract. It's important to understand what terms of a contract are. You can think of these as the provisions that make up a contract. In certain cases, if these terms are breached, then they can give rise to litigation. So in this video, I'll be describing what a term is, how they are formed, and what happens if they are breached. So what are terms? These are statements of rights or statements of obligations. So parties in a contract, they have rights, and these rights would be stated as terms, so as provisions in the contract. Parties can also have obligations. So various parties need to meet obligations, and these would be specified as provisions in the contract. The terms are binding. So if a statement or if a provision is classified as a term, it means that both parties, or if you have two parties in the contract, both parties in the contract would be bound to perform or to abide by the terms that have been specified. How are terms formed? There's three ways that terms can be formed. Mostly they start off from the negotiation process that happens before the contract is formed. So you have two parties. Let's say, for example, your construction contractor, and then you have the principal, the developer. Negotiations would be taking place between these two parties. And depending on the statements that are made, some of them would be inserted in the contract, and these would form the terms of the contract. Some terms are actually implied by law, so they haven't been necessarily incorporated into the contract by the parties, but the law comes in and inserts them. And the law can insert them based on the conduct of the parties during negotiations or after the contract was maybe formed. It can also be inserted because of custom. So in an industry, say in construction, people do things in a certain way, and that custom that's formed in that industry gives rise to certain implied terms in any contract that takes place within that industry. And the final way that terms are formed is through expressly including the terms in the contract. So parties have agreed on these terms in the negotiations, and they've agreed for these terms to be incorporated into the contract, either orally or in writing. Now, the express terms is the most common way of forming terms. So it's where the both parties have agreed to include the statements as terms in the contract. As I said, they can be oral express terms or written express terms. For you to make sure that the terms are included and considered by the court as incorporated into the contract, make sure that the terms are expressly written in a contract. Implied terms, as I said, they're inserted by the law, and it's based on, most likely it's based on custom. So in a particular industry, sometimes it's based on the conduct as well of the parties. So if certain parties in the contract behaved in a particular way, that conduct can give rise to a term that needs to be included, even though it wasn't expressly included by the parties. The law would come in and would force that term to be included as an implied term. Pre-contractual negotiations, they're a bit tricky because there's a lot of things that I said in the negotiation process. So how would you classify whether what's said would form a term or whether it's just like a mere statement? A mere statement would be referred to as a representation. Now, a representation is not binding. Uh, Only terms are binding. So the law needs to find a way of classifying whether what was said in the negotiation process would be considered as a term versus a representation. And the law does that through an objective test. So the law would ask, what would a reasonable person have, you know, have understood from the intentions of the parties that are involved? Was it an intention for the statement to be included as a term, or was the intention not to include that statement? And I'll talk more about that in a separate video. The important point, however, to note is that terms, when breached, they can give rise to litigation. So if you breach a term, then the injured party can sue you for damages. Now, if the term is classified as a condition, that's really bad, because in that case, the party can terminate, the injured party, the aggrieved party can terminate the contract. If the term is classified, however, as a warranty, then the party can only sue for damages. If it's a representation, on the other hand, it's not legally binding, and hence there is no remedy in the common law. However, in recent years, statute has stepped up, and there has been legislations that have been introduced to make sure that, you know, certain parties in a contract are protected. An example of that would be Section 18 of the Australian Consumer Law, where if the conduct of one of the parties was to lead to deception, or would be classified as misleading conduct, then um, the injured party can get a remedy that is in statute. But in common law, usually if it's a representation, it's just a mere statement, and hence it wouldn't give rise to any litigation.